Pleasant good evening to everyone. We want to thank our virtual audience for being here as this evening the Member of Parliament for Cumuto, Manzanilla, the Honorable Dr. Rai Ragbeer, will be joining with members of his fellow MPs, where today we are in a public consultation to discuss the repealing and why we should repeal the Procurement and Disposal of Property Amendment Act of 2020, better known as the Procurement Act. This evening, I shall be moderating this event. Brian Baig is my name. I am the Research Officer for the Member of Parliament. I also this evening will be bringing my own views as a practicing attorney at law on this legislation. This afternoon we have a packed event led by the MP for Cumuto, Manzanilla, Dr. Rai Ragbeer. We have a powerhouse and a financial consultant, a man who has a history in our banking sector, Mr. Ved Siriram. We have the man who has the Senate heated, Senator the Honorable Andrew Roberts, who I will always say is the best Minister of Sports that this country has ever had. We are here today because we have seen what the Rowling-led administration has done. They have taken a legislation that was meant to ensure that there was no corruption in the public sector, which was done under the People's Partnership led by Kamala Prasad Sessa. But yet you have Dr. Keith Christopher Rowley, who came with his government and gutted this legislation and made it less of what it was meant to be. The powerhouse speakers here today shall show why this legislation has to be repealed. In fact, it must and should be repealed in all forms. I want to thank the Honorable Kamala Prasad Sessa, Leader of the Opposition, and the next Prime Minister of Trinidad and Tobago for championing this, for ensuring that this goes out. We have been doing our duty, as the constituents have already placed their signature on a much needed petition, which will be spoken on much further. But without further ado, I want to bring on a gentleman, a man who is of the people, a man who has been there from ground zero, a man who has been there since elected. In fact, just today, he has been almost every part of his constituency. I speak none other than a man who has had years of service in the medical fraternity and now has been bringing service to a constituency called Cumuto, Manzanilla. I want to bring on none other than the Member of Parliament for Cumuto, Manzanilla, Dr. Rai Ragbeer.
Good evening, one and all. Good evening. Right. It's lovely to be here. Thank you, Brian Baig. To our political leader, Kamala Prasad Sessa, I bid you a good evening, my dear, of my political leader, and I thank you for your choices you have made in this party. To the constituents of Cumuto, Manzanilla, my hat is off to you, and to all the UNC family that is on live, I bid you good afternoon. As a medical doctor, I am here and I want to insist on you, especially with 70 COVID cases today, that all COVID protocols have been adhered to. I will not have it any other way. And I'm sure everyone here, my heart goes out to the people of St. Vincent and the Grenadines. And you know, today marks exactly 42 years since 1979 that they had a volcanic eruption. That is so amazing. And look at Barbados, which is about 94 miles away or so from some, the whole country is covered in ash. And I understand that the weather pattern says we may have a 20% chance of a fallout. They used to say God is a Trinity. But you know what? As the political leader says, we put God in front and we behind. What we say, we pray. And especially tomorrow marks a very significant day in Islamic calendar, start of Ramadan. And just a day or so ago was Navratri. Isn't Trinidad a wonderful place where we have different religions, everyone come together as one people because Lent has finished. So the United National Congress, here we are, through the guidance of the political leader, to embark on public discussions of the Procurement Act 2020 and to have petitions signed by the public asking Her Excellency, the President, to have this act repealed. So, friends all, what did we do in Cumuto, Manzanilla? We were the first constituency to have about 1,000 signatories that we have engaged our constituents, and we getting more. The leader has confidence that we are getting more signatures. So before we get into our discussion this evening, I want to thank the panel that is here this afternoon and the time that they are taking here to explain to the public why we are here. Because you keep hearing the word procurement. P-R-O-C-U-R-E-ment. M-E-N-T. What does it mean? Procurement is a system where you buy and sell goods and services in the government sector. This is where the government will put systems in place to acquire goods and services. One such way the government did this was introducing the Central Tender Board Act. This legislation was brought in the early 1970s. I see some members of the audience, it wasn't born yet. Now we fast forward where we are today, and I want to remind the public that it was a people's partnership led by Kamala as Prime Minister, the best Prime Minister ever, that the procurement legislation was actually brought to the Parliament, debated and passed. And furthermore, my friends, the PNM, then in opposition, tried everything to frustrate the process. In fact, they also absconded from the Joint Select Committees. However, we have before us a gutted, you know what about gutted? They take out the good stuff and put stuff that makes no sense. Legislation of what was done before. The Rowdy-led government has made the legislation a sham in what it was intended for. As MP for Cumuto, Manzanilla, I stand with the leader of the opposition and support the call for the repealing of the act. And my friends on the head table will give you a reason why. But a doctor foremost, but I want to share something with you. Some of you may fondly remember the costly cancellation of not TT dollars, US dollars, 72 million US dollars on a contract that was signed between state-owned, the HDC, and a Chinese construction firm for the construction of 5,000 homes. My friends, they canceled the contract 4 months after the fact, when the public interest elements lobbied against the basis of terms which was hugely disadvantageous to the interests of the people of Trinidad and Tobago and well beyond best practice. So that's what the Procurement Act is about, making sure we do things properly. The PNM, the Prime Minister, Dr. Rowley, washed his hands with no punishment like Pontius Pilate of the responsibility of this disaster, saying the contract has no cabinet acceptance and approval. But guess what, my friends? No one was ever held accountable. So this shows a lack of accountability and transparency having been played out. And you know what is worse? It hurts your heart. A flagrant expenditure of the public purse. So we are here this afternoon when they talking about the Procurement Act, when we say about they want to avoid certain services, legal services, financial services, accounting services and audit services, even medical services, that they will not be part of the Procurement Act, which my colleagues will talk about. And you know what? The minister will also have the right to include other services as they see fit. And they'll bring it to Parliament and do what they want. And that's why the political leader wants to repeal that. We want to avoid corrupt practices such as bribery, bid rigging, and you have seen so recently last few years a fire sale of state enterprise for little or nothing, for the 1%, and wastage of taxpayers' dollars. And we hear about bid rigging, and I will tell you a little thing about it's an illegal practices. It's where the competitors get together and say, here what, you take this contract, you bid this amount, right? Next time will be my turn. How that can be right? This is where prices will be higher, more cost overruns, the quality of goods and services will be inferior, taxpayers will be burdened with this extra money to be paid, and guess what? You have an inferior product. So you don't understand why we are here this afternoon. So to make it right, it is ungodly, it is unjust that we can allow people to just buy things, procure goods and services without any transparency, remember the word, and accountability. So that's why we have this forum here this afternoon, where at the end of it there will be a question and answer, because I'm sure you will have some questions to ask. My friends, I want to thank each one of you all for coming out, and to the members of the audience there, do enjoy your afternoon and be COVID safe. Thank you, God bless.
Thank you, Dr. Rangel. Let's give a hand for our MP again now. And from what the MP has said, it is quite clear. It is crystal clear. In fact, I'm going to borrow a phrase. It is pellucidly clear that this act must be repealed. It has to be repealed. Because clearly, the PNM has done injustice to the people of Trinidad and Tobago with what they have done with this legislation. So my friends, let us now introduce a gentleman, a man who is a stalwart in the financial sector. Let me take this one. A man who I would say is a financial connoisseur. He has a history in the banking sector. He is a man that is able to speak on this matter. He's a financial consultant. He also served in the Senate in 2010. I wish now to introduce Mr. Ved Siriram, financial consultant.
Thank you, Mr. Chairman. Honorable Member of Parliament, Dr. repeal, distinguished panelists and members of the audience, members of the viewing public, good afternoon. We are here to talk about the procurement and disposal of public property legislation and the impact of the amendments regarding the management of public assets and public money. No doubt the Act in its original form was a major step in the right direction, where all arms of government and state enterprises would have been subject to a uniform code of conduct and rules with regard to the procurement and disposal of public property. In addition, the regulator, as proposed in the Act, would have had the responsibilities to ensure that best practices were employed and that they had the authority to regulate the process and apply penalties when due. The regulators would have the gargantuan task of training a vast number of civil servants and state enterprise employees engaged in the procurement and disposal process, including management and directors. The government, in its wisdom or lack thereof, has introduced many exemptions that render the Act impotent. The disaster of such amendments have been well articulated by the opposition, and we heard today from Dr. Raghav, civil society, the law association, and many chambers of commerce. The President is yet to proclaim the legislation, and while we are calling for to rescind the Act and resubmit it to Parliament, there is a step that we could call in between, where we can ask the President not to proclaim the Act in its present form. So I hope the President, in her wisdom, could take that step, given the evidence, given the gutting of the Act in its original form, that the President, if she has any contribution to make to the development of Trinidad and Tobago, should take that step without any request by citizens of Trinidad and Tobago. If the President is to act in the best interest of the country, she would simply refuse to proclaim and recommend the bill be resubmitted in its original form. The President must exercise discretion to steer the country from a very bad piece of legislation. Failing her rejection of these amendments, it would not be unreasonable to question the purpose of the position of the President. This is subject to another time. The amendments effectively created two sets of regulators, one being the regulator as proposed in the bill, and the second being the Minister of Finance. This is a recipe for disaster. The exemptions created by the amendments include government-to-government contracts, public-private partnership, finance and banking, accounting, legal, medical, and any such services that the Minister of Finance may determine. Such exemption makes the Act impotent, and therefore we should not be wasting, if we do accept these amendments, we should not be wasting money, taxpayers' money, in supporting the regulators. The whole regulators for procurement should be abandoned and allow the minister to do as he pleases. However, we have to recognize this is a retrograde step in the development of the practice of democracy in Trinidad and Tobago. Let me address some of these amendments. Government-to-government contracts. This was not defined in the Act, unfortunately. What exactly does a government-to-government contract mean? Regarding, let us look at the procurement of vessels from Australia. What role did the government of Australia play? Was it just a conduit by recommending certain contractors to satisfy our request for the ships? Did the government build the vessels? Was the financing made by the Australian government or through one of its agencies? Was the Australian government party to any agreement with the government of Trinidad and Tobago? All of these details are not known to us. Was the Australian government acting as a broker, putting the deal together? I'm sure none of us in the room can answer that question. Regardless of the definition of government-to-government contract, the fact remains that such contracts are not devoid of mistake, nor are they devoid of corruption. Was there any precaution done by our government regarding the value for money on the vessels? How was this process conducted? In other words, what was the decision process that the government undertook when they bought the vessels aboard from Australia? Was there any evaluation of the cost of financing, or was it lost in the overall package? Were alternative supplies for vessels considered? All these questions must be answered if we are to protect the public purse. How did government arrive at the decision for the vessel procurement from Australia? No one in Parliament, perhaps not even in Cabinet, fully understands the process that took place. And here it is, the government and Cabinet is managing public funds, and the public is being kept away from understanding what precisely transpired. Can our government put their heads on a block to confirm that this was the best deal on the table? Regarding the engagement of many Chinese construction firms, would these contracts be considered government-to-government contracts? If so, why? Why would such contracts be exempt from the regulators? The bottom line is, no contract should be exempt except for low-level sums. In other words, there should be a threshold where the government will have certain discretion. Even for the purchases under that threshold, government is still required to abide by proper principles. Let us look at the public-private partnership. If you exclude public-private partnership, then every purchase, every contract could be designed as a public-private partnership and therefore escape the purview of the regulator. Let's look at some facts that were given. The Act defines, unlike government-to-government contract, where that was not defined, the public-private partnership in the Act, it defines what that meant. And it engages, it involves an arrangement between the government and private companies, where the private companies provide some assets and services, and the government actually retains some interest in that particular project. Let us look at some of the construct or some of the transactions that could fall under the public-private partnership. We would recall the bill-owned lease transfer, that's the bold arrangement, as in the case with the Tobago House of Assembly. In that transaction, the THA sold the parcel of land at a low price to a private company. If that was subject to the Act, whatever transaction took place with regards to the land, as stage 1 in the complex transaction, that would have been subject to third party at an arm's length transaction, and therefore the cost of the land would have been subject to third party review. In this particular transaction, we do not know what was the price of the value of the land that was transferred to the private company. The private company and the THA entered into a bolt arrangement where the company will construct a building and lease it back to THA for about 20 years. The THA was supposed to put up about $20 million up front. The THA will contribute a large sum up front, and that was represented as an initial lease payment, which is a very unusual arrangement if you are leasing a property or leasing something, an asset. The company, however, will build the building and maintain the building during the time of the lease. At the end of the period, the lease period, the property will be transferred back to the THA. No one knows the actual details of that transaction. However, millions of dollars could have been lost to the taxpayers, and it was not brought, the details were not brought to Parliament for discussion, and we have to question now all of these private-public partnerships for a simple reason. Let us look at the petroleum refinery, what will prevent the government from leasing the refinery to any private partner, and government can retain one share, and that become a public-private partnership that will also escape the purview of the regulators and the purview of Parliament. We know for a fact, with regards to the gas to liquid plant, the government did sell the plant via a liquidator, but somehow they ended up with preference share to the tune of $25 million US. So that again is a public-private partnership that also would have escaped. So the bottom line concerning the private-public partnership, I'm saying that should be taken out and that should be included, should not be included as an exemption. So so far, government to government should not be exempt. Private-public partnership should also not be exempt. Let us look at finance and banking. This is an area where the treasury of the central government and the treasury of large state enterprises have been pillaged for decades. The Ministry of Finance do not have the knowledge nor the experience, nor do the state enterprises have the knowledge and experience to manage large bank loans and raising either bonds or by way of consortium loans. The examples are too numerous, and let me give you a few examples that I have personally been involved in terms of investigating on behalf of government and on behalf of Petrotrin. The government interest rate swap transaction, where they lost $75 million on a 10-minute call. The government yen swap transaction, which is still on the books, the government may be losing in excess of $1 billion. And this is not a case where the Ministry of Finance personnel were deliberately corrupt, but they were certainly incompetent and they were taking advantage by investment banks from New York and from other parts of the world. The point here is whether the regulators would have had a second overview of those transactions and would have had the experience and the knowledge to bring to the government's attention as what they were doing wrong. There was a transaction done in the late mid-90s, where we may remember a Trintoma Petrotrin transaction. The government and Petrotrin, and they were still suffering under that predatory lending, and they were paying over 35% interest rate when the market rate was less than 5%. Quite recently, or not too long ago, Wasa raised a bond for $1 billion and they paid a fee of over $300 million. This was under the Manin regime. And here again is that they are not fully equipped to manage the predatory lending of investment banks. That is why, I don't know if you remember, during the debate, the Attorney General said that they would like to exempt finance from the regulators because he was advised by the investment bank that the investment bank would feel very uncomfortable if somebody else were looking prying into the transaction that they were offering. And that is precisely one of the reasons why they should not exempt financing and let competent people deal with those transactions. But what was worrying was that the Attorney General fell into the trap of these predatory banks and came to Parliament and made an argument to exempt financing from. Financing is the last thing to be exempted from the regulators. There was another transaction in the early 2000s where Caribbean Airlines, they showed a profit for the first time. I think it was 2002. And that was a bogus bastard transaction organized by the bank, where they actually sold an airline and leased it back. That was what you call the appearance of the transaction. But in fact, it was a loan disguise. And if you are not competent in financing, you will not be able to understand it. You'll walk away bewildered, However, the public purse will not be protected, and that was a fraudulent transaction that should have been investigated, and the bank should have given back the government all the profits they made on that deal. So therefore, finance and banking must not be excluded from the purview of regulators. That's a no-no. Hopefully, I'll be delighted to talk to the President on these matters so that she can understand. I think the UNC should ask for a meeting with the President to explain all the flaws in the event that these exemptions are accepted. So the regulator is expected to provide control on proper evaluation of financial bids. A major problem is the elementary method applied to evaluation. When you're evaluating bids, there are severe flaws in terms of government practices with regards to those evaluations, and that has to be strengthened. Hopefully the regulators, assuming that there are no exemptions, that they will develop the skill and training to make a proper evaluation of bids that come before them. There are some other issues which I would like to mention. When should the regulator get involved in evaluation? Is it that the ministry, the government, will say, look, we are going to buy certain ships and we have gotten about 5 bids, come and evaluate it? Or should the regulator determine by some method whether those purchases are relevant? Are those purchases relevant in today's world? Is the airport relevant in today's world? Airport in Tobago relevant in today's world? If government is committed to buying or investing or constructing, at what point should the regulators get involved? When I read the act, it was not clear. But as far as I could see, that the regulator must determine whether there was a cost-benefit analysis, whether it will bring benefit to the citizens of Trinidad and Tobago, or whether it will be a shackle, a debt shackle over the neck of our future generation, our children and our grandchildren. So, who prepared the justification paper? And that, quite frankly, should be under the purview of the Parliament. The opposition must get involved and demand that they look at all the feasibility studies and give approval for it. If the opposition do not do that, they will be failing in their duty to protect the interests of the citizens of Trinidad and Tobago. So they must demand that all those proposals must come before Parliament for discussion. In fact, there is, I think, in 1 or 2 countries that they already have that condition in place. So, in the case of the sale of Petrotrin, at what stage was the regulator to have gotten involved, assuming it was not exempt? Private partnership or sale was not exempt. But this is such a critical area. Trinidad has been badly affected by the closure of Petrotrin, whether we like it or not. They were a net earner of foreign exchange, and on that basis alone, Petrotrin should have been kept open. Why was it closed? Where was the feasibility study? On what basis was that being closed? And that should come to Parliament for debate, an open debate, so that we as citizens would be aware of the particular pros and cons of a particular decision or recommendation, and be party to it, because these are billions of dollars of our taxpayers are being spent. So therefore, another very important condition is that no investment must be made without a feasibility or justification study. Where was the justification feasibility study on the Sandals Tobago project? There was none. This is amazing. You have $50–60 billion under the control of one person, the Prime Minister. We have gutted the independence of the Permanent Secretary. We have gutted the independence. In other words, none of our Permanent Secretaries are bold enough to tell the Ministers, sir, this is against the law for a certain reason. Sir, this is not viable. What happens today, and we are seeing it, the evidence, is that the permanent secretary, they carry out the wishes that they perceive the ministers have. And this is extremely dangerous and it must stop. The Tobago Sandals project is an example that no country should follow, none whatsoever. So I want to make this caveat, establishing a regulatory body do not guarantee good governance. At least it's in the right direction, it does not guarantee. We have seen the failures of regulators. The Clico crisis was as a result of the delinquent central bank. The SEC failed to restore justice in the FCD IPO scandal and they settled it out of court. However, establishing the body is a step in the right direction, but we have to go further. But let us get back the exemptions onto the Act as a first step, and later on I will recommend you deal and strengthen the regulation as it's now presented. Can government do what they want? I'm posing this question. Can government do what they want? The Sedition Act is being challenged as unconstitutional. Can this procurement law also be challenged on the grounds of unconstitutionality? And this is where our attorneys, if they are worth their salt, they should be looking at this and coming up with some kind of defense or some sort of court case to challenge the unconstitutionality of the Act. The main purpose of government is to establish policy and laws that would be in the service of transparency and equity and in service of the citizens. The government also has a fiduciary duty to the citizens. The government has this duty whether they recognize it or not. Fiduciary duties means a duty to act in the best interest of the party you represent. And the government represents all citizens. The government, once they are in place, they do not represent the party from which they belong. That is extremely important. Their allegiance, their loyalty must be towards the citizens of Trinidad and not to their party. So this has to be debated for us to fully understand and comprehend what are the wrongdoing being performed by the government. So fiduciary establish a duty on the government to justify all expenditures and account for all such expenditures not only to the Parliament but effectively to the citizens of Trinidad and Tobago. So the government is required to establish independent institutions that will ensure proper checks and balances with regard to the public purse. The traditional view is that government do not owe the citizens a fiduciary duty. However, in 1984, in Canada, there was a tilt where it was ruled that fiduciary duties do in fact exist. And I will urge the attorneys in Trinidad, not only the attorneys that represent and work with UNC, but all attorneys, to look at the fiduciary duties that government owe each citizen of Trinidad and Tobago. And if that is well established, then you will see the exemption as now proposed in the Act would be overturned. So we need to explore. On a last vote, we have to consider the role of Parliament in decision making. The opposition must not be excluded from any decision making. Good governance and good democratic practices require widespread participation to include the opposition and civil society. We need not reinvent the wheel, but look at best practices. I've learned recently that in Ghana, all government contracts with foreign companies must be debated and passed in Parliament. Why cannot we tomorrow present that in Parliament for debate and enactment? Secrecy and confidentiality, that is the normal excuse. Why would somebody be secretive with my money? Why would somebody be secretive with your money? That's a very strange arrangement. So confidentiality is the first sign of smoke that may be hiding a raging fire. They always claim confidentiality. What is so confidential about the price that we pay? The price that the parties have to pay for gas. What is so confidential about that? I would suggest that the amendment be rejected and the original act also be strengthened in the very near future to include global best practices. Thank you for your attention.
Thank you very much, Mr. Siram. Let's give Mr. Siram a round of applause. Mr. Siram, what you have done here this evening has been very edifying. And I must say I have learned a lot from just listening to you. I would say that the nation is very much, I would say, grateful for what we've heard today. And we must thank the United National Congress political leader Kamala Prasad for having such consultations to bring persons like Mr. Siram to speak to you all, to see why it is when these petitions are being done. Yes, we've done 1,000 signatures, but we're going to go back out again. So you, the people who are seeing this, you will know when we come to you all, you know why it is important to sign such petition. Ladies and gentlemen, I am now pleased to present to you all a very hard-working man. A man who was, I will always say, is the best sports minister of Trinidad and Tobago. He was a minister of sports under the People's Partnership. Now he is in the Senate. And he has been fighting for the people in the Senate. I speak none other than Senator the Honorable Anil Roberts.
Good evening and a special good evening to the Member of Parliament for Cumuto, Manzanilla, Dr. Rai Ragbir, and all of our UNC family. Procurement, gutting of the procurement legislation, as labeled by Senator the Honorable Wade Mark, is legalized thieving. What has been Keith Christopher Rowley's track record on procurement and corporate governance? Let's go back a little bit. If you all go and read the report from the Integrity Commission on the land data fair, you will know that something was untoward, that some gravel rolled from by a hospital to somewhere by Keith Rowley. If you go to Shorelines and you see the towers high up in the air, you would have known that citizens had tried to get approval to go up in the sky in that area for decades and had been denied by the Ministry of Integrated Planning and Development, because there was a codicil back in 1964 that said that anybody buying land there on constructing cannot go up above 2 or 3 stories. But however, Keith Christopher Rowley became the Minister of Integrated Planning and Development back in 2003. And in August of that year, his friend, his good friend, and the man who he wanted to be the chairman of the PNM party, not Franklin Can, John Rahal, his son Joseph Rahal joined with 2 gentlemen at Woodgill Limited, joined that company, and then they made the application once again. Now it must be noted that Woodgill had been denied on 1 or 2 occasions already for planning outline approval to go up in the sky in that area. But in August of 2003, Joseph Rahal joined, and miraculously, by the 3rd November 2003, just 3 short months later, Woodgill Limited got outline approval by ministerial approval signed by the hand of Keith Christopher Rowley, the Minister of Integrated Planning and Development back then. Shortly after, days after, Patrick Manning moved him into housing. And what happened in housing when he went there? First of all, he found his Superman now, Noel Garcia, and they proceeded to be the most incompetent duo in the history of the Ministry of Housing. Across Trinidad and Tobago, as reported in The Guardian 2 years ago, and then the story was dropped like a hot potato. Under Keith Rowley's tenure as Minister of Housing, with his #1 guy, Noel Garcia, approximately $1.8 billion of projects went incomplete or could not be finished, and money was wasted, including the Edinburgh Towers, in which there are procurement issues right now as they try to restart those projects, and the tender procedure was scuttled. And I ask right now, even with that project, Noel Garcia. What was the tender procedure? Why was it scuttled? Was the winning bid for approximately $4 million? And is UDCOT now doing it in-house, utilizing the scaffolding that they had from the Red House project, the over-budget, overtime Red House project? Is that scaffolding enough? Is UDCOT now going to have to purchase scaffolding for some $12 million in order to try to revamp that project down in Edinburgh, in Chaguanas, those eyesores that are Rowley and Noel Garcia? Is the approximate cost now $27 million, which is $23 million above what a company tendered for and won the tender before it was scuttled? But moving on, Las Alturas, Noel Garcia, Rowley, Greenvale, with Al Rawi on the board of the HDC. Then Camille Robinson Regis was the Minister of Planning, Integrated Planning and Development, replacing Rowley. And she denied, and she said that HDC could not purchase nor build houses on that land in Greenvale because it was floodplain land. All of this is procurement. And that the change of use would be denied for housing because it was prone to flooding and it was agricultural land. Rowley, as Minister of Housing, issued instructions to the board and they went ahead. They purchased the land. Do you know whose land it was? It happened to be John Rahal's land. And they went ahead without approvals to build houses there, and we know what has happened. Even though the UNC came in with Dr. Munilal and tried to mitigate and make ponds and access areas and increase drainage, the flooding was still detrimental, dangerous situation for citizens who lost everything in some floods in 2016, 2017. But that was Rowley. And there are countless projects across Trinidad and Tobago that were just left because Keith Rowley and his board with Noel Garcia and Faris Al-Rawi at the HDC went ahead with projects without approval. When the Guardian asked Keith Rowley, but what was this? Why did this happen? He said sometimes to expedite things you have to go ahead without approvals. He admitted in the Guardian newspaper article on the front page, I still have it, that he broke the law in order to expedite projects. This is a man who was then elevated to Prime Minister. When the People's Partnership was in government and Botiwari was doing this procurement legislation and discussing and bringing it and laying it and brought it to the Parliament and put it to a joint select committee, Keith Rowley, as leader of the opposition, and his PNM thwarted the work of the GSC by not attending. They tried to delay. They do not want procurement legislation, and their track record shows it. They delayed it. They did not come. They did not have a quorum, and therefore the partnership had to change the standing orders to try and change the quorum so that the work could be done. So when they got into power based on Emailgate lies in the Parliament, the procurement legislation had been there and had been approved 3/5 majority by the People's Partnership under Kamla Persad-Bissessa. And for 5 long years, nothing happened under Keith Christopher Rowley. Nothing. One excuse after the other, one deadline after the other. With Colm Imbert, the Minister of Finance, talking about regulations. They appointed a regulator, paid people a salary with no job, no teeth, no proclamation, no procurement oversight. Then they came in a gerrymandered election under an EBC with the niece of a former sitting minister and the best friend of a sitting Minister of Education now. And the first thing that they did was bring amendments to gut the procurement legislation to make it absolutely useless, to provide the regulator with no power whatsoever to remove legal fees, medical supplies and services, and government-to-government relations. Remember Keith Rowley as Prime Minister. He is the man who met with every CEO across the board, every CEO to procure. He created a new item in procurement called Ministerial Committees to Procure the Galleon's Passage, which was supposed to be the lease of a fast ferry. It instead turned out to be the purchase of a slow ferry, which they then told us was for a port that has not even been designed yet. Then he created a situation where himself and his super minister, the now Minister of National Security, would go down to Australia and procure ferries, vessels, and Coast Guard vessels without an iota of procurement, no advertisement, no competition, no tendering, no evaluation committee, no permanent secretary, no board, no tenders committee. And we have accepted that. So when we are faced now with a gutted procurement legislation, Keith Rowley has shown that track record throughout. Even when he built his Tobago sheep farm, he did it without the EIA and the certificate of environmental clearance from the EMA. That is Keith Rowley. That is the Prime Minister. So when they come now to amend and dilute and delete the procurement legislation, do not be shocked. It is legalized thieving in your face, and the only way to get rid of it is sign the petition, get rid of it, and repeal the procurement amendments brought by Faris Al-Rawi, who has rented out his own building from himself to himself. God bless. I'm listening and locked on, and thank you, Dr. Rai Ragbir. Bless.
Thank you very much, Senator Roberts. So let us give Senator Roberts a round of applause there again. Now, this evening I come to you as well to speak on this legislation that was gutted, that was taken apart, that was an atrocity done by the PNM. My friends, when this bill was brought, these amendments was brought to the Parliament, the question that must be asked is, were there any consultations? The reason why I ask that is because in 2010, the JCC and other stakeholders, there were many consultations held with the People's Partnership. In fact, they even brought packages to recommend to the government. The government and People's Partnership, within 30 days, took those recommendations from persons like the JCC and other members of society. And when they went into a joint select committee. Now, as you know, the Member of Parliament, Dr. Ragbir, spoke about that JSC. Now, at that JSC, it must be reminded to the public that the PNM members who were in opposition did not attend any of those joint select committees. They refused to be a part of it. So now they came to government and they brought this. And it's a sham. It is a disrespect to the people of Trinidad and Tobago. So that's why I am here today to say that such legislation of this 2020 Act must be repealed. It must be repealed now. I will look at a certain clause in this bill, or act rather, that needed to be looked at. I speak other than clause 5 of it. Clause 5 deals with the legislation which applies the following services provided to public bodies or state-controlled enterprises, that being legal services, medical services, financial services, and other such services as the minister may determine. What the government is doing basically is they're setting up a parallel procurement process. That cannot be right. How can you set up a parallel thing when you set up, there's already something in place? That cannot happen. So my friends, I will go into that a bit. I will go into that a bit further. I want to also talk about that for those who don't know, and I'm glad that we are doing these consultations, that we must know there was a Freedom of Information application that was done to the Cabinet of Trinidad and Tobago. And that Freedom of Information request, it asked as to how many times did the Attorney General recuse himself from the Cabinet. It also asked how many times did the Minister of National Security recuse himself as well. Now, we must understand the reason for asking about these recusals. There were existing procurement matters that went before the Cabinet. I can tell you, my friends, that from a letter we are told that July 7, 2020, that from 2016 to July 7, 2020, Minister Young recused himself from the cabinet 57 times. Let me say that again, Minister Young recused himself 57 times. The Attorney General recused himself 38 times. That makes a total of 95 times that they recused themselves from the cabinet. Now, what was the reason for these men recusing themselves? It is quite clear that there were things that were brought to the cabinet for a cabinet approval that these men had an interest in. So what they do? They just recuse themselves. Something come, step outside. Something come again, Attorney General, step outside. So, is that right, my friends? No. The answer to that is what? It is no. And these are our lawmakers. And I think, Mr. Siram, you made quite clear that if the cabinet is breaking the law, then my God, that is why the president must repeal this legislation. Because they are now allowing for the cabinet to be a parallel organization that cannot be allowed. My friends, I want to go back to clause 5, which deals with legal services. Now, why would the government want these services to fall under the Procurement Act? We must never forget that it was the PNM who was in opposition that talked about the whole issue of awarding briefs and people getting briefs. But we now see just recently that somebody who is a relative to a member of the cabinet just received a legal brief from the office of the Prime Minister. How that person got it? How they got it? Was there any application? Was anything sent out? Was there an advertisement? No, it is himself to himself. But we all know who recused himself, I'm sure. So my friends, is that even right? That cannot be right. So that is why they exempted that. And that clause shows one main reason why this bill or act must be repealed. I now again want to now refer again to clause 5. Under clause 5b, financial services. And Mr. Sira, I want you to hear this. Do you know in 2018, there was an award of a mandate to NCB Global Finance to arrange a 10-year fixed rate loan to the amount of, you know how much? $180.3 million. And that was awarded through cabinet. And do you know a minister had to leave cabinet to recuse himself? I wonder which minister had to recuse himself. And that was awarded. Let me go further. So we have the 2018 award. But also, we have in the year 2020, there was an award to the same NCB Global Finance Limited to provide a 125 fixed rate loan for WhatsApp. So again, we understand that a minister had to recuse himself. And we know who had to recuse himself. So my friends, this again shows that they came and used the legislation to have something exempted. So, Mr. Shiram, you're quite correct. The cabinet is using this to award their friends and their family. And this cannot happen. We must always remember that the tentacles of politicians must not be allowed in the public purse. And we must not have that. I want to look at now clause 5D, which deals with medical services. Now, Dr. Rai, you would like to hear this. The medical services I want to show you. In 2018, the Attorney General had to recuse himself because the matter being considered by Cabinet was a proposal for the continued engagement of private healthcare institutions for the provision of surgical, radiological, and lab services for patients for the public healthcare system. So the question I must ask is, why did the Attorney General recuse himself from medical services? Is the Attorney General, I don't remember him being a doctor. Is he a doctor, Dr. Rai? I don't recall him being a doctor. Anybody know if the Attorney General is a doctor? I can't recall. Mr. Chairman, you know he's a doctor? I can't. So why is it he had to do that? And is it that he had an interest in this company? And why did he see the need to recuse himself after actions again? So my friends, in 2018, the proposal for the continuing engagement for, hey, what is for? Surgical, radiological, lab services. What do the Attorney General have to do with that? I just can't understand it. But they went and bring in the legislation to exempt from medical services. So again, somebody framing something. So again, we have to show that there's a parallel system that is being put in place. And that is wrong. This is not what the procurement legislation was envisaged for. The procurement legislation was brought about to ensure that there is no corruption. And this, my friend, is corruption. Now imagine this, I wonder if anybody had to recuse themselves to find out if they had an MRI in Tobago. Remember when the Prime Minister wanted to get an MRI or something done? And he didn't get that done because he had none. Maybe somebody should recuse themselves to find out why you have none. So this is a definite conflict of interest, and because of this section, under this clause, it shows that the government had plans in place to ensure that their people could benefit, and that is not right. I want to move on to the issue of constitutionality of this legislation. Now, for those who don't know, when the procurement bill was first brought by the People's Partnership, this bill was passed with a constitutional majority in the Parliament. But however, this Attorney General is bringing legislation that does not need a special majority. I know he loves to quote such pieces of cases like Surat, and I'm sure he's going to talk about it again somewhere and somehow. But we must let it known that this piece of legislation, when it was brought, did in fact deserve to be passed with a special majority, and they did not do it. So my friends, we have to also look at why it is the government is doing this. And also, with the coming of this legislation, I must ask a question, and Dr. Ryan, you are in the Parliament, so I'll ask this question through you. Where are the regulations for this legislation? Regulations is key for this legislation. Regulations will help to ensure that this legislation is enforceable. There is no regulations. So someone needs to find out why is this not being done. And if there is no regulations, then repeal the legislation now and repeal it now. It has to go. I want to commend former MP Tim Gopi Singh, former Attorney General Anand Ramlogan, who ensured that this legislation had to come about. As you all know, they sat on the JSC and they did a tremendous job. I think we should give them a round of applause for how the bill was in its parent state. Do you know that they did consultations with the regulators for Jamaica? They also went about and ensuring meeting with people from the IDB, the World Bank, to get this legislation come in place. So I talked earlier about the lack of consultation, and it shows here that the People's Partnership did consultation. So my friends, it is showing again why it is this act must go. The government has done everything to gut this legislation, to take it apart, to dismantle it, and by dismantling an independent institution called the Procurement Public Regulations Office. Do you know that this also, because of this bungling of this government, it led to the resignation of the deputy chairman of this office, of the public regulator? And you know the sad part about it is that when this man resigned and talked about how this government has not done the right thing, instead of the government looking to do the right thing, they chastise that man. They chastise him, and that is wrong. That is government, how you say it? Governance, P&M style. And that is wrong. So, my friends, I want to say here tonight that I, again, must recall and say it again, that this act must be repealed, it must be taken out, it must be removed forthwith. I call on the President to ensure that this bill is repealed. And I want to commend the Honorable Kamala Prasad Misesa for having these type of consultations happening nationwide. This is a lady who is a leader of the people. This is a leader who knows how it is to govern. And I say thank you for having me here as well, Dr. Rai. Thank you very much. Ladies and gentlemen, enjoy the rest of your evening. Long live the United National Congress. Long live Kamala Prasad Misesa. Thank you. Right. So again, let's all thank all persons who are here this evening. We're going to have now a question and answer segment. I do know we have some persons here who are prepared to ask some questions for members of the panel who will be willing to answer your questions. So anybody else, you will come up here, you can ask it here, and then the panel will then answer after. Thank you.
Thank you very much, Mr. Chairman, members of the head table, the Honorable Member of Parliament for Cumuto, Manzanilla, Dr. Raghuram. My question here tonight, could the lack of accountability in procurement involving foreign governments and companies lead to those administrations and institutions determining Trinidad and Tobago's agenda timeline for developing projects? That's my question, Mr. Chairman.
Thank you very much, and I will take a crack at that. There's an old saying that he who pays the piper calls the tune. If a major economic power like China decides to back a project in little Trinidad and Tobago, it is obvious that they would pull the strings with respect to terms and conditions. China has a project called the Belt and Road Initiative, in which they are getting involved in infrastructural developments, in which countries so far that have gone into 70 countries. China promotes economic development, but on their terms, China has its own political and economic agenda and would bring pressure on host countries to support the plan of action. Without transparent procurement terms, it is easy that there are to be hidden features in such agreements to support the Chinese government of China or Chinese companies. There are serious issues, and the future of Trinidad and Tobago governments will find themselves saddled with secret contracts, and this can affect our economy. So, I thank you for your question, sir.
A pleasant good night, everyone, members of the head table, honorable MP. My question for tonight is, could this flawed amended act cause Trinidad and Tobago to be further downgraded on the International Perception of Corruption Index? That's my question.
Dr. Rai, you will take this question.
Thank you for that question. The question you asked about corruption. Well, under the KNN, corruption is the name of the game. So of course, Trinidad and Tobago is now ranked among the most corrupt nations in the world. You can Google it. Because this Rowley government has ensured that we have reached such a deplorable state in our financial sector. So when the government refuses to provide the data and significant details on billion-dollar contracts, it is obvious that this country will be seen as a corrupt country. After all, why would any government refuse to provide disclosure to its citizens on the use of their hard-earned money? It is taxpayers' money. No one wants to invest. Listen to this. No one wants to invest in a corrupt society. Why I said that? investors would fear to bring their money into the country. So we asked, for the last 2 years, how many investors have come into Trinidad and Tobago to invest so that the lives of our citizens have increased? Maybe none, if any at all. Government has not yet made any investor, and I want you to remember that. And all of us know there's a significant shortage of foreign exchange. So this means that the country cannot buy foreign goods. And as my learned colleague Manzanilla said, we should have kept Petrotrin. It's an earner of foreign exchange. And guess what? As a doctor, medications are running short and will continue to run short. The basic necessity of food, goods, services, all that depends on foreign exchange. So when these investors come, they bring with them foreign exchange. And as I said in my bit, is that when we have a fire sale of our patrimony, like Petrotrin and other industries, that's going for little or nothing. My friends, we're in trouble. Thank you for that question.
Good night, everyone that's here tonight. My question for tonight is, could Trinidad and Tobago become the political satellite of China or another international power and serve as an axis as a result of the terms of such non-disclosure agreements?
Thank you very much for that question. This is a concern not only of small states like Trinidad and Tobago and the Caribbean countries, but all over the world. China, as you know, has a grand design for the Belt and Road Initiative, where transportation means are being constructed all over the world, where China, in fact, will have a dominant influence and dominant control. We are seeing it in terms of Pakistan, where they have invested billions of dollars in having roadways, bridges, and infrastructure so that they can access the Arabian Sea from China. There's no question that China, apart from the economic impact, is that when they advance funds to any country, there are conditions to it. Recently, in one of the, I think in Tanzania, where they advanced money to build a port with the understanding that they will have to get repaid over 33 years. The president said, look, we cannot make those payments, and what China did was raise the interest rates, change the conditions, and said, okay, well, then you lease us the port for 99 years. The president of Tanzania said, no way, we are going to stick to the lower interest rate at the 33 years, and we are not going to. But the instructive lesson there was that China was imposing their will to change the policies of those countries. The other major reason why China has embarked on their aggressive influence all over the world is that they get their votes in the United Nations. They have loyalty among several countries. So whenever votes come up in the United Nations, these countries are obligated, failing which China can actually twist their arms. So the question of, we have to be very careful. Let me also make a caveat. Other countries have done the same over the years. So it's not to say that it's a practice only by China. But all the major countries have done it. It's just that China has done it in such a grand scheme that we have to be very cautious going forward.
should CARICOM, an international agency such as of American States, United Nations, and Commonwealth, be lobbied on the Trinidad and Tobago government lack of commitment to probity in procurement legislation? That's my question.
I love that question. The people of Trinidad and Tobago should speak out about what the PNM government is doing. We should lobby these international agencies so that the PNM government does not want to account of the people's money. Letters should be written to these powerful organizations advising them when the government is engaging in secretive multi-million-dollar contracts. We know that these bodies would not interfere in domestic affairs. That's fine, we know that. However, we must bring it to their attention nonetheless to let them know that you have a government that is stealing the people's money in front of your eyes. And I believe that we should. Thank you.
My question is, should the overall cost of current contracts that do not meet international procurement benchmark be calculated and presented nationally and internationally?
Yes, thank you for the question. This is precisely the point where we have transparency to address issues such as this. Because if the overall cost of current contracts that does not meet the international procurement benchmark be tabulated and presented nationally and internationally. All of this, there should be a monthly statement reporting to Parliament with regards to these contracts. And that's why one of my recommendations is that all the major contracts above a certain limit, and certainly all the contracts with international suppliers and international companies, be subject to parliamentary discussion, debate, and overview. I cannot tell you how important this is, because these are billions of dollars being spent by government without the purview of anyone. And if the legislation is passed with the exemption to the removal of those important clauses, then we are going to see the rapid waste of whatever little resources that are left in Trinidad. At the moment, Trinidad is spending borrowed money and we're in a very precarious economic condition. So I cannot agree with you more regarding this matter.
Thank you very much. Let us give our panel a very warm round of applause. Well, ladies and gentlemen, this is where we bring an end to our public consultation. We do ask that all of you all who are here, we are still carrying out our petition to be signed. Because we're looking to have more than 1,000 persons coming from Cumuto, Manzanilla. And I know we can do it. Did I say 2,000 plus every? So with that, I will thank all of you who are here. Continue to stay safe, continue to follow the COVID regulations. And on behalf of the Member of Parliament, I'd like to say thank you very much for being a part of this. And again, we say, repeal the Procurement Act now and do it now. Thank you. Have a good night.